Welcome back to another explainer. And wow, today we are looking at something incredibly intense. Seriously, I want you to imagine a strategic legal playbook that's designed to do the unthinkable, literally dismantle the absolute authority of a judge right inside their own courtroom. The source documents we're analyzing today outline this incredibly radical theory. It's essentially a step-by-step method attempting to break down the justice system from the inside out. It's like this massive high-stakes puzzle, and we're going to piece together exactly how this strategy is built. We're going to explore the meticulous, almost architectural way this framework tries to reconstruct the rules of the game to empower you, the individual, over the institution.
Okay, let's dive into this. Just close your eyes for a second and picture a courtroom. Who holds the ultimate power? I mean, you almost certainly pictured the person sitting high up behind that heavy oak bench, wearing the black robe, right? We're conditioned from birth, by every movie, every TV show, every news report, to believe the judge is the absolute, undisputed authority in that room. Their gavel is the final word. But the legal theory we're unpacking today challenges that basic assumption to its absolute core. It argues that true power doesn't actually belong to the judge at all. In this framework, that black robe is effectively just an illusion of authority.
So these source texts operate on this one massive foundational premise, and it's this: a court is the person and suit of the sovereign. Now think about that, because it completely flips the traditional script. According to this framework, a court doesn't belong to the government, it doesn't belong to the state, and it absolutely doesn't belong to the judge. It belongs to the sovereign, which in this theory is you, the individual. If the court is simply a manifestation of your own authority, well, the entire dynamic of who's actually in charge shifts dramatically. You're no longer just a guest in the judge's arena. The court literally becomes an extension of your own sovereignty.
But before we get into the heavy mechanics of how this actually works, we have to look at where this playbook comes from. These concepts originate from an educational framework known as court university. Now, these texts present a highly structured, radical interpretation of the law, and their main goal is to teach individuals how to establish what they call a true court of record. This specific type of court is the exact vehicle they use to try and completely strip the judge of power. It's an entire curriculum really built around reverse engineering the legal system, using historical definitions to fundamentally alter how a modern courtroom operates. Let's look at the actual blueprint, because to execute this legal strategy, the sources argue you can't just waltz into a government building, stand in front of a judge, and declare yourself the sovereign. No way. It requires immense, absolute precision. You have to formally establish this true court of record. And the texts treat the requirements for this court like critical pieces of a high-stakes puzzle. If you're missing even one single piece, the whole strategy just falls apart. You end up trapped in what they call an inferior court, where you have absolutely no power and the judge retains complete control over your fate. So building this court requires 4 mandatory rules. Ready? 1. It must keep a perpetual, permanent record of proceedings. 2. It needs the inherent power to fine or imprison for contempt. 3. It proceeds exclusively according to the common law. Now, this third rule is massive, by the way. The texts explicitly state this strips away all statutory codes. That means things like standard statutes of limitations completely vanish from the equation. And finally, number 4, the tribunal must be independent of the magistrate. Every single one of these 4 rules has to be perfectly aligned to unlock the strategy. Now, what's really interesting about this is that 4th rule. It is the absolute linchpin for this entire legal strategy. Out of all the requirements, this is the one that actually triggers the paradigm shift. The demand that the tribunal must be entirely independent of the magistrate is the exact mechanism used to systematically dismantle the judge's authority. It's basically the tactical strike of this whole playbook. To understand how they pull off this legal judo, we have to look at how they rigidly define those 2 terms, totally separating the power to decide from the power to administer. Honestly, think of it like the difference between a powerful corporate CEO and an administrative assistant. First, you have the tribunal. The texts define the tribunal as the entity that actually thinks, exercises judgment, and makes substantive decisions. They're the CEO. In a true court of record, this is the sovereign plaintiff, or a jury of your peers. Then you have the magistrate. The magistrate only has ministerial and administrative authority. They can process the paperwork, sure, but they cannot make the rules. And according to this playbook, the judge is merely the administrative assistant, the magistrate. We really need to hammer this specific definition home, because the entire strategy relies on it. A magistrate is defined here as an official entrusted merely with the administration of the laws. No thinking, no discretion, absolutely zero judicial decision-making power. If an official is a magistrate, they're essentially just a highly titled clerk.
They manage the schedule, they make sure the microphones work, they stamp the paperwork, but they cannot legally rule on the facts of the case. They are entirely stripped of the very thing we assume a judge is there to do, judge. And here is the ultimate reveal. This is the trap the source material lays out, using the state's very own codes against itself. Look at California Penal Code Section 808, which is prominently cited in the texts. It literally says, the following persons are magistrates, the judges of the superior courts. Boom. By pointing to this specific real-world statute, the authors argue they have legally trapped all judges. The law itself legally defines the judge as a mere magistrate. It is a breathtaking use of legal irony, weaponizing the system's own foundational definitions to bind the hands of the person at the bench. So the crucial point is that when you combine these definitions, they form this potent legal weapon. Just follow the logic like a mathematical proof. Rule 4 demands that the tribunal, the one actually making the decisions, must be independent from the magistrate. The state's own penal code legally defines the judge as a magistrate. Therefore, logically within this framework, the judge can never, ever be the tribunal. In one fell swoop, checkmate. The judge is entirely stripped of any discretionary or decision-making authority within that specific courtroom. And that brings us to the climax of the playbook. By invoking a court of record, the author claims you relegate the judge strictly to ministerial duties. Ultimate power is transferred completely away from the bench and handed directly back to the independent tribunal, which, again, is you or a jury. And it actually goes a step further into some truly shocking territory. The texts claim that if the judge tries to make a ruling anyway, they're acting outside their jurisdiction. They can actually be held in contempt of court by the sovereign plaintiff. It's a complete and total role reversal of the modern justice system. The texts use this logic to completely redefine the entire court system. According to them, a true superior court is solely a court of record that maintains that independent tribunal we just talked about. But if you walk into a building with a shiny sign out front that says superior court and a judge starts making decisions for you, well, the texts argue that is actually an inferior court. It has violated the fundamental rules. And because it's deemed inferior, its decisions carry no legal weight. They're open to what's called collateral attack. In simple terms, that means the inferior court's rulings can be completely ignored, sued over, or invalidated, later a true court of record. The core theme running through all these documents is what happens when a system is challenged from within. The gravity of this legal theory is massive. I mean, whether this framework holds up in reality or not, it represents a highly structured, aggressive attempt to totally dismantle standard judicial authority. It's just a fascinating, intense look at how individuals are attempting to fundamentally rewrite the mechanics of our justice system. They aren't trying to change the laws by voting. They are weaponizing historical definitions, common law, and existing statutes against the judges themselves to seize control of the room. We've broken down the blueprint, we've seen how they attempt to strip the judge of power, and we've analyzed the mechanics of this radical legal playbook. But it leaves us with one profound final question to really chew on. What happens to the very fabric of our legal system when it is dismantled using its own definitions against itself? Class is now in session.